Chapter 9, we're going to look at contract performance, breach, and remedies. Typically, only the original parties to a contract have the rights and liabilities under that contract. There are some exceptions that we talk about in this chapter: assignment, delegation, and third-party beneficiary contracts. Assignment is a transfer of contractual rights. Later, we'll talk about delegation being a transfer of contractual duties. The parties in an assignment: the assignor is the one who makes the assignment. The assignee is the one the right is assigned to. An obligee is somebody who is owed a duty or obligation, and the obligor is the one who owes that duty or obligation. So an assignee can assign rights or things they're going to receive in a contract to some third party, and those rights then pass to that third party, the assignee, who has a right to demand performance from the original party to the contract, specifically the obligor. Assignment's prohibited when there's a law against it, when it's personal in nature, when it would materially change the rights or duties of the obligor, or when it will significantly change the risk or duties of the obligor. Once an assignment is made, the assignee should notify the obligor of the assignment. There's no real duty to do this notice, but it's in the assignee's best interest. One of the issues that comes up is if notice isn't given, who has priority? What if the assignor assigns the same rights to two different people? The obligor can discharge his obligation by performing to the assignor. As we mentioned, delegation is contractual duties delegated to a third party. Delegator is the one making the delegation. Delegatee is the one the delegation is made to. The effect is that the delegation is enforceable. The obligee must accept performance from the delegatee to whom the duties are delegated. However, the valid delegation doesn't relieve the delegator of the duties under the contract. In other words, if you contract with somebody and you delegate those duties to someone else, you're still responsible for ensuring they get done. Duties that can't be delegated: if performance depends on the personal skills or talents of the obligor, some special trust relationship in the obligor, the third-party performance will materially vary from the contractual expectations, and when a contract expressly prohibits delegation. Third-party beneficiaries exist when the original parties to the contract intend to benefit someone else who is not a party to the contract at the time of contracting. Makes both parties a promisor. A third party's rights are vested when the third party demonstrates express consent to the agreement, when the third party materially alters his or her position in detrimental reliance, or when the conditions for vesting are satisfied. For example, in a life insurance policy, once somebody dies, then a third party beneficiary's rights would vest. A couple intended beneficiaries. A creditor beneficiary is somebody who benefits from a contract in which the promisor promises the promisee to pay a debt the promisee owes to a third party. A donee beneficiary is when a contract is made for the express purpose of the promisor giving a gift to a third party, a donee, and the donee can sue the promisor directly if the promisor breaches the contract. As we mentioned, intended beneficiaries can bring an action to enforce the contract. An incidental beneficiary is somebody who is not intended to benefit at the time of the contract, and they can't sue to enforce the contract. Let's look at contract discharge. There are different ways a contract can be discharged. It could be by condition, by performance, by agreement of the parties and operation of law. A condition would be a possible future event, the occurrence or non-occurrence of which would trigger a performance of legal obligation or terminate an existing obligation. In other words, it's a condition that would cause somebody to have an obligation to continue in a contract, or it would cause them to be able to avoid a contract. In condition precedent, subsequent, and concurrent just has to do with the timing of that condition. So sometimes there's a condition that precedes a party's obligation to perform. Discharge by performance. Complete performance would be perfect performance, where the parties do exactly everything that's required. That's fairly rare. What the court's looking for is substantial performance. A party who performs substantially in good faith can enforce the contract. Basically, they confer most of the benefits. The benefits or performance doesn't vary greatly from what was promised. This is what we would call a minor breach. It would entitle the other party to damages. You also could have a contract that requires satisfaction of someone. We call this a satisfaction contract. When the contract is personal, the subject matter is personal, the actual personal satisfaction is required. Otherwise, we're looking at a reasonable person standard. In other words, somebody's satisfaction couldn't be unreasonably withheld. We'll look at material and minor breaches of contract. A breach of contract generally is the non-performance of a contractual duty. That breach is material when performance is not substantial, and the non-breaching party is excused from performance. They're also entitled to damages. If it's a minor or non-material breach, the duty to perform is not excused on the non-breaching side, and they have to resume their performance. Anticipatory repudiation means you think there's going to be a breach. Before the performance is due, one of the parties might refuse to perform or appear as if they're not going to be able to meet the contractual obligations. This would be treated as a material breach if the other party admits they're not going to be able to perform, and this would entitle the non-breaching party to bring an action immediately for damages versus having to wait to see if the other party performs. But notice by that repudiating party, the party who is leading to the anticipatory repudiation would restore the original obligation. In other words, if I told you that I'm going to breach the contract, but before you change your position, I told you that I am now able to fulfill it, then you would need to wait. Discharge by agreement could be by rescission, novation, or accord and satisfaction. Rescission means that the parties agree to undo the contract. Novation would be for the old contract to go away, a new contract to replace it that contains a party from the old contract and a new party. Sometimes this is called substitution. And accord and satisfaction would be where there is a contract but somebody offers to perform something different, and the other party says that would be sufficient. So example, I owe $10,000, but I offer to pay $8,000, and the other party takes $8,000 now versus waiting to try to collect $10,000. That would be an accord and satisfaction. The law could discharge a contract. Perhaps it gets altered by one of the parties. The other party who's innocent would be discharged from that. Statute of limitations, if somebody waits too long to sue under a breach of contract, then the contract would be discharged. They wouldn't be able to recover. Or bankruptcy is a way of discharging contracts by operation of law. Sometimes it's impossibility in a situation where it's not foreseeable. This could occur by death or incapacity of the parties, the subject matter of the contract is destroyed, or the law changes and makes the contract illegal. There could be temporary impossibility that suspends performance, or a situation where it's not impossible but it's commercially impractical, and again the performance would need to be extremely difficult or costly and not really foreseeable by the party at the time of the contract. Or frustration of purpose, something intervenes, makes it impossible for the parties to attain the purpose they had in mind when they formed the contract. There are different types of damages in a contract. Compensatory typically is the difference between the value of what was promised and what was actually performed. Incidental damages would be damages in addition to compensatory damages that could be linked directly to the breach. And a sale of goods is the difference between the contract price and the market price. And a sale of land, perhaps the party would ask for a specific performance because they want the land versus the damages. Consequential damages would be foreseeable losses that a breaching party is aware or should be aware of. Punitive damages would be to punish the other party. This is not common unless there's some type of tort, for example, fraud involved. And nominal damages would be like $1 when there's no actual losses, but technically there's a breach. Mitigation damages is the innocent party being required to reduce their damages if possible. Liquidated damages would be the parties agreeing in advance to pay a specific amount upon breach. The court will enforce those unless they're a unreasonable penalty. Generally, the court won't enforce those. And the questions that the court asks are listed there. There are also equitable remedies: rescission, restitution, specific performance, and reformation. We've talked about rescission generally, backing out of or undoing the contract. Restitution would be returning goods, property, or money. Specific performance would be making the party perform the acts they promised in the contract. And reformation would be to rewrite the contract to reflect the party's intentions. This is common in a situation where there's fraud or mutual mistake. It could be quasi-contract, and we've talked about that before in terms of it being a contract that the court creates when there's not a contract. And the requirements are that there's some benefit conferred to the other party takes that benefit, the party expects to get paid when they provide that benefit, and letting the other party keep the benefit without paying would